General principles of justification. So justification, self-defense would be a justification. Defense of property is a justification, meaning these are legal defenses of confession and avoidance. So you're confessing to the underlying conduct. I shot at that guy to defend myself. I shot at that guy to defend my property. I concede that. I'm not denying that. But even though I concede to that underlying conduct, that's the basis for the criminal charge against me, whether it's murder or manslaughter or reckless endangerment or aggravated battery with a firearm, that I should nevertheless be free of legal liability because the conduct was justified, meets the conditions of self-defense, which this really doesn't, or defense of others, or meets the conditions for defense of property. Now, Pennsylvania has a fairly typical defense of property structure, particularly in the context of defense of personal property. And the rule is that although there are circumstances in which you can use force in defense of property, there are no circumstances, personal property, there are no circumstances under Pennsylvania law where you can use deadly force in defense of personal property in the absence of a threat to persons. And if there's a threat to persons, it's not really a defense of property scenario anymore. It's a defense of persons scenario. So what do we have? Use of justifiable force to protect property. Now, we do need to distinguish personal property, which I would classify as least protectable property under Pennsylvania law, and really the law of every state except for Texas. And we'll get to Texas in a moment. Personal property, only non-deadly force in defense of personal property in the absence of a threat to persons. There is highly defensible property, like your home, for example. Sometimes a place of business, sometimes an occupied vehicle also qualifies as highly defensible property, where you do get special provisions for the use of deadly force in the context of defense of highly defensible property that you do not have in the context of the defense of least defensible property. But here we're talking cash money. That's personal property. And it's a lot of cash money. But the defense of property law doesn't say you get to go to deadly force in defense of personal property if it's valuable. It doesn't list the dollar amount. It doesn't matter how valuable it is. If you're using deadly force in defense of personal property in any state but Texas, it's going to be unlawful. So, Section 507, use of force justifiable for protection of property. The use of force upon or toward the person of another is justifiable when the actor believes such force is immediately necessary. And this combines interference with personal property, what they call tangible property here, and trespass on open land. I'm only going to address the tangible, movable property issue relevant to this video. It's justifiable when immediately necessary to prevent or terminate the unlawful carrying away of tangible, movable property if such movable property is believed by the actor to be in his possession or in the possession of another person for whose protection he acts, or to effect or retake tangible, movable property if you believe the person who's taken it is not taking it under authority and some other conditions. That's not occurring here, right? The cash wasn't taken and the owner is trying to retake it. The good guy's trying to retake it. In fact, the armed robbery was never successful. Was never successfully executed. It was defeated before the desired property could be seized. Limitations on justifiable use of force. The use of force is justifiable under this section only. This is always a good one. Some states have this provision. If the defender first requests the person against whom such force is used to desist from his interference with the property. So first you're expected to ask the other person to stop. Well, the reason they have this kind of provision is because they're concerned about innocent takers. So you can imagine you're in a restaurant that has like a common coat rack. You hang your coat up there like everybody else has on a cold day. And some other patron of the restaurant has a coat that looks very similar to yours, maybe identical to yours. Maybe you both shop at Costco. And he accidentally takes your coat and is walking out with it. You recognize it as your coat because of a unique coffee stain on it or whatever reason. Before you use force upon him to recover your property, they want you to request that he stop what he's doing. So maybe we can prevent this unintentional taking with a simple verbal request. But you're not required to make the request if such a request would be useless, or it would be dangerous to yourself. Obviously, under these circumstances, it would be dangerous to yourself. Let's see. Let me scroll. Here we get to it. Subsection I here. The use of deadly force is justifiable as defense of property if there has been an entry into the actor's dwelling. So the use of deadly force is restricted to highly defensible property, your castle. So someone's made an entry into your dwelling. The entry is not lawful. And the defender reasonably believes that force less than deadly force would be adequate to terminate the entry. But the only context under Pennsylvania law in which deadly force in defense of property would be permissible would be in the context of your dwelling, of your home, of your castle, not your $100K in cash in the car with you. And I think that's all I wanted to cover there. So in the absence of a threat to persons in this video, which occurred in Pennsylvania, there is no legal justification for the use of deadly force against that person who was just committing an armed robbery. What about other states? Let's take a look at Florida. This is Florida's general self-defense statute, 776012. And it's interesting because it has a generalized catch-all forcible felony provision. The first paragraph here is the use of non-deadly force in self-defense, but we're interested here in the use of deadly force in self-defense. Paragraph 2. A person is justified in using or threatening to use deadly force if he reasonably believes using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or another, or to prevent imminent commission of a forcible felony. So we have the defense of persons, and all the elements are in that sentence if you know to look for them. And then we have this catch-all to prevent a forcible felony. Imminent commission of a forcible felony. What is a forcible felony under Florida law? Well, we have a statute for that, 77608. Forcible felony means treason, murder, manslaughter, sexual battery, carjacking, home invasion robbery, burglary, arson, kidnapping, aggravated assault, aggravated battery, aggravated stalking, aircraft piracy, unlawful throwing, placing, or discharging of a destructive device or bomb, or any other felony which involves the use or threat of physical force or violence against any individual. Now, when you look at this, obviously they list robbery as a forcible felony. We have a robbery taking place in this video, an aggravated robbery, a felony robbery with a deadly weapon with threat of deadly force harm. But if you look at these forcible felonies, what do they all have in common? They're all really threats to persons, right? So carjacking is different than car theft because it requires the car's occupied. There's people in the car. That's really what's being protected. Arson, you may think of as a property crime. You're burning property, but it's treated as a crime against persons because of the uncontrollable nature of fire and the risk that there's people inside the dwelling. So traditionally, deadly force is permitted to prevent the imminent commission of an arson. And then the last portion here kind of gives it away, or any other felony which involves the use or threat of physical force or violence against any individual. So really, these are defensive person provisions. I mean, we think of robbery as a property crime, but robbery is different than theft because theft is just the taking of some piece of property that doesn't belong to you, conversion of its use to your use without authority or permission. Robbery is taking property with threat against the person, right? By threat of force or violence against that other party. So really, it's a threat to persons act, and defending against robbery is a defense of persons defense, legal defense. But we don't have any of that in this video while this car is driving away. I mean, there is no armed robbery occurring anymore. And the Florida catch-all for forcible felony says the imminent commission of a forcible felony, not flight from a forcible felony. What about another state? Texas. Texas is the interesting state. the only one that allows for the use of deadly force in defense of even mere personal property. Now, there are a lot of loopholes that need to be jumped through. I will say I have seen this statute used to justify the use of an effective use, actual killing, the use of deadly defensive force to defend mere personal property in the complete absence of a threat to persons and have it be completely justified. I know of a case where a husband and wife were out to dinner. They were walking down the street, coming back from the restaurant, and some dude walks up and grabs the wife's necklace and rips it clean off her neck and just starts running down the street. And the husband just pulls his pistol, takes aim, shoots, kills that guy, drops him right there. They recover the necklace. They call the police. They explain what happened. And the cops say, well, if that guy didn't want to get shot dead, he shouldn't have stolen the necklace. Because the conditions for the use of deadly force in defense of mere personal property were satisfied under those circumstances. Let's take a look at what those conditions are. So deadly force to protect property, and we're talking here about just personal property, items, undeveloped land, things like that. Least defensible property, by the way, which includes your pets. Your pets are least defensible property. I know you feel like your pets are members of your family, just like the humans in your family, maybe more so, depending on the humans in your family. But legally, they're just personal property. Now, of course, this Texas provision that allows for the use of deadly force in defense of personal property would also, in Texas, apply to your pets. A person is justified in using deadly force against another to protect land or, and they mean open, undeveloped land here. They don't mean land like your home. Your home would have a different, as highly defensible property, would have a different standard for the use of deadly defensive force. To protect land or tangible, movable property, so personal property, first, you have to meet all the conditions for the use of non-deadly force in defense of property. This is Texas Penal Code 9.42, deadly force to protect property. 9.41, referenced here, is non-deadly force in defense of property. So first, you have to read 9.41. Make sure you meet all those conditions. If you do, then you also have to meet these additional conditions for deadly defensive force. When and to the degree he reasonably believes that deadly force is immediately necessary to prevent the other's imminent commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime. So this would be satisfied, right? Because we have an aggravated robbery here, which is enumerated. Even a simple robbery would be sufficient. Or to prevent the other who was fleeing immediately after committing burglary, robbery, aggravated robbery, or theft during the nighttime from escaping with the property. Now, this is an interesting question because, of course, there was an attempt aggravated robbery, and now the robber is fleeing, but did he commit the robbery? Is he fleeing after commission of the robbery? I mean, you could argue it both ways. One is that, well, yeah, you commit the robbery even if you're unsuccessful in the robbery, right? At least it's an attempt, although this doesn't say attempt. Now, clearly, if this robber had seized the $100,000 and was running away with it, well, that would qualify under this paragraph as well. And the defender would have to believe that the property cannot be protected by any other means. Well, you're facing a gun here, so what other means would you use? And the use of force other than deadly force would expose the defender to substantial risk of death or serious bodily injury. So all of this would be satisfied, I would argue. The only question is, can you still do it while the unsuccessful robber, is in flight? I think that's an open question here.